Are you a parent involved in a really contested and nasty custody case or dependency and neglect case, and suddenly the judge has appointed a guardian ad litem, and you're wondering what in the heck that is and what do they do? My name is Patrick Slaughter. I'm an attorney with LaFevor and Slaughter, and I'd like to tell you, a guardian ad litem is just a fancy Latin word because lawyers like to use Latin because it makes it sound smarter than we actually are. But a guardian ad litem is just an attorney that has been appointed by the court to represent the children's interest. Now, a lot of attorneys and parents get this confused and think that the GAL, as we call them for guardian ad litem, represents the child. Well, that's true and it's not true. The child doesn't get to dictate what the GAL does. The child will provide the guardian ad litem with information. I'm sure the guardian ad litem will conduct an investigation by talking to the child's school, potentially their doctors, their dentists, friends, family members, things of that sort. And we'll probably talk to the child and ask the child what the child would like. But the child doesn't get to dictate what the guardian ad litem recommends or the guardian ad litem does. That guardian ad litem is an attorney. And in some cases, like a guardianship case, a guardian ad litem may be allowed to give a report to the court. However, in most contested custody cases and dependency and neglect cases, the guardian ad litem doesn't get to give the judge a report, but gets to ask questions of witnesses and present evidence the same way any other attorney would. So the guardian ad litem is a person that you definitely want to be on your side. And the best way to do that is to be honest with them, answer their questions, give them the information they need. Don't try to get cute and say, but technically, because that technically will come back to bite you in the behind. Work with the guardian ad litem, work with your attorney to work with the guardian ad litem, and things will probably come out fine. But, perhaps you're on the winning side of the case and you think, well, the child's going to tell them this and I'm going to get what I want because little Joey or little Barbie is going to say what I want. Doesn't work that way. I've seen plenty of cases where guardian ad litems have gone to court and said they would recommend exactly the opposite of what the child would want. I remember one particular case where the child wanted Nutella whenever the child wanted it and wanted to have pizza for dinner every night. Naturally, the guardian ad litem did not recommend that. So guardian ad litem, again, is just an attorney that's appointed by the court to represent the child's interests. Now, as far as paying for the guardian ad litem's fees, that can be an interesting subject. If the guardian ad litem is appointed in an indigent case, in other words, one or both of the parents doesn't have sufficient resources to hire an attorney, and the judge appoints an attorney for either or both of the parents and then appoints a guardian ad litem for the child, typically those costs will be borne by the state. However, if one or both the parents is not indigent and is capable of hiring an attorney, particularly if they've shown up to court with private counsel of their own, it is likely that the judge is going to require that the parties to either split the guardian ad litem fees, and that split could be 50-50 or it could be any other percentage based on what the judge deems to be appropriate. So guardian ad litems don't typically work for free. Sometimes they're paid by the state, sometimes they're paid by the parties. So you want to make sure which one of those is going to be involved in your case so you can budget to be able to pay your lawyer and potentially a guardian ad litem as well. That way you won't be caught with any nasty surprises at the end. These are kind of strange circumstances, and if you find yourself in a situation like this and you're wondering, what do I do? I've got this guardian ad litem and maybe I don't believe they're cooperative or maybe I don't know how to cooperate with them. Perhaps you need to talk to an experienced family lawyer to be able to give you some good pointers on how to deal with that or what actions you can take to make sure that the proceeding is fair. Feel free to pick up the phone, give us a call. Be happy to answer those questions, and if we can give you any advice, we'll be happy to do that as well. But in the meantime, do your best to make the guardian ad litem your friend. They represent the child's interest, not necessarily what the child tells them, and keep that in mind when you're going forward with your case.